So let's talk about why The Witcher Blood Origin, does not work.
And contradicts not only book lore, but also lore that Lauren and Netflix has set themselves.
I gotta be honest with this one. I think this was the most painful thing I've ever had to review.
It obviously is the worst show of 2022.
Honestly, what an absolute mess.
A 9% audience score.
Let's just say the first episode was absolute unmitigated trash. Well, there's good news, folks. The second episode is exactly the same.
Netflix may find itself in some scorching water due to its recently debuted show, The Witcher Blood Origin. And this is for more reasons than the fact the show is universally considered to be an abhorrent entry into the Witcher franchise. The new controversy surrounding this rancid program is tied to a claim made by an artist named Shawn Coss. This artist is accusing Netflix, via Twitter, of using his art in certain background shots of the Witcher Blood Origin series, without his express permission. In a series of tweets and retweets, the artist shared side-by-side comparisons of his work and certain sketches which are clearly visible in certain shots of the Witcher Blood Origin series. Artwork which, if actually is his, he claims to have never allowed Netflix to use in a streaming program. Now you may ask yourself, isn't something like this fair use? I mean, they seem to be pretty insignificant shots from these tweets. And of course fair use meaning an excused form of copyright infringement. Or is this use by Netflix so minimal and so trivial that this doesn't even merit our attention? It doesn't even merit a legal claim. Well, the question you're trying to ask yourself is actually a specific legal principle. That question is, would the court call this the minimis use of another's copyright? The minimis use is the idea that some forms of copyright infringement are simply too insignificant for courts to spend time on. The full phrase is the minimis non curat lex, or translated to, the law does not concern itself with trifles. Certain forms of minimal copyright infringement are simply so minor that courts will not consider there to be an actionable claim, despite the offending party being technically in the wrong. The most obvious case of this is if you have certain art appearing in a motion picture incidentally, far off in the background, so that even while you're watching it, you can't really make out what the art actually is. Although technically, someone used your art without permission, no one cares because you can't tell what it is, you can't really quantify any kind of damages from that kind of art use. So the question for Shawn Coss, if he were so inclined as to bring a lawsuit against Netflix, would most likely revolve around how discernible his art actually is within the television show, or for how long the art is visible. Is it no more than a fleeting glimpse of his art? Or does a particular shot within the series linger on his artwork? Maybe linger a little bit too long. To kind of figure out the template for determining Netflix's culpability, we can look at a few famous examples in case law. Now I want to note before I get into these, all of these examples come from the Second Circuit, meaning they aren't binding precedent in California, should that be where the case is brought, which I assume it will be. I think that's where Netflix has its headquarters, and I assume as an artist that's where Shawn Coss resides, but of course I could be wrong. But these cases do give a good idea of what one might expect, regardless. So the examples include cases involving the film What Women Want, the film called Seven, and a television show called Rock. In the case involving the Mel Gibson picture What Women Want, there was a scene in which Gibson and his co-star Helen Hunt are brainstorming with other employees to develop ideas for marketing certain consumer products to women. At various points during the scene, a pinball machine can be seen. The Silver Slugger was a machine distributed by plaintiff Gottlieb Development LLC, and Paramount Pictures, which released What Women Want, used the pinball machine in the scene without that distributor's permission. So Gottlieb sued Paramount, alleging that Paramount engaged in copyright infringement by using the Silver Slugger machine in the movie. Now, what's protectable about a pinball machine? Well, the Silver Slugger featured 3 original designs protected by copyright. A depiction of a baseball diamond on the back glass, another baseball diamond on the playfield, and the layout of parts of the playfield. In other words, there was some artwork that was featured on the machine which is protected by copyright, And that's not mentioning the trademark claims that could have been brought or were brought, but I'm not going to get into those right now because those are a separate topic. So the scene for this movie, the What Women Want scene, the scene was 3.5 minutes long in total. The pinball machine appears only for a few seconds at a time. It's always partially obscured by Gibson, a recliner chair, or a bar stool, so you never get a full frame kind of picture of the pinball machine on its own. The Silver Slugger does not appear in any shot isolated by itself, nor is it in any way part of the plot. No one mentions it, no one references it, no one touches it. It's just sort of there as a set dressing, set prop. It does not appear anywhere else in the film, nor does any character ever refer to it. An average observer would not recognize the designs on the pinball machine as anything other than generic designs of a pinball machine. The best that an average lay observer could make out in the background is just a typical home plate layout with some baseball players arrayed around it. They couldn't kind of tell the unique aspects or the unique expressive elements of the designs. Those aren't discernible in those brief moments when the pinball machine is actually visible. A very kind of simplified way of looking at this is you can tell there's some art there, but you can't really tell what that art is. In Sandoval versus New Line Cinema, there was a very similar dispute, this time involving copyrighted pictures that were used as set dressing in the Brad Pitt and Morgan Freeman film Seven, directed by David Fincher, quite a good movie. The plaintiff in this case created a series of unusual black and white self-portrait studies. The series contained photographs of the plaintiff, Sandoval, with his face tightly wrapped with wire, with his face covered by soap bubbles, and lying on what appears to be a bed of thorns. Now, in one scene, Brad Pitt and Morgan Freeman are searching an apartment, and on the back wall of that apartment is a large light box with a number of photographic transparencies kind of attached or pinned to it. 10 of those transparencies affixed to that light box are reproductions of Sandoval's self-portraits. So like before, let's kind of take a look at the facts the court noted when it was doing its analysis. So the scene in total lasts 1.5 minutes. Sandoval's pictures, or portions of each, are briefly visible in about 11 different camera shots. The longest uninterrupted view of the light box featuring the pictures lasts only 6 seconds, but the box is otherwise visible in whole or in part for a total of approximately 35.6 seconds, according to the court. The photographs never appear in focus, and except for 2 of the shots, are seen in the distant background, often obstructed from view by one of the actors. In these 2 shots where they are more visible, the figures in the photographs are barely discernible, with one shot lasting 4 seconds and the other for only 2 seconds. Moreover, in one of the shots, after 1.5 seconds, the photograph is completely obstructed by a prop in the scene. So just like the case of What Women Want, in light of these factors, the court ruled Sandoval's photographs as used in the movie are not displayed with sufficient detail for an average lay observer to identify even the subject matter of the photographs, much less the style used in creating them. Finally, we have a case which was actually considered to be infringement and not the minimis use of art. This case involved the HBO show Rock. The plaintiff in this case was Faith Ringgold, a successful contemporary artist who created and owns the copyright in a work of art entitled Church Picnic Story Quilt. So let's get to our facts. In one scene where there's a recital taking place, the show decided to use the Church Picnic Story Quilt as a background prop. The quilt is visible during a 5-minute scene of the music recital in the HBO show. The Church Picnic poster was used as a wall hanging in the church hall where the recital takes place, and at least a portion of the poster is shown a total of 9 times. In some of those instances, the poster is at the center of the screen, so contrast that with the previous cases. Although nothing in the dialogue, action, or camera work particularly calls the viewer's attention to the poster. The 9 sequences in which a portion of the poster is visible range in consecutive duration from 1.86 to 4.16 seconds. The aggregate duration of all 9 sequences where the quilt is visible is 26.75 seconds. So the court's finding based on these facts was that an average observer can see what was hung is some form of artwork depicting a group of African American adults and children with a pond in the background. The brevity of the segment and the lack of kind of perfect focus preclude identification of the details of the work. But the 2-dimensional aspect of the figures and the bold colors are seen in sufficient clarity to suggest a work somewhat in the style of Grandma Moses. In other words, It did not matter that an average observer would be unlikely to tell the exact painting by watching the episode, but it was enough to constitute actionable copying that an average observer could kind of infer what the painting was depicting and what style of painting it might be. So to recap, based on these cases, I think there are several questions we can sort of extrapolate as being determinative of whether something is de minimis or not. So here are the questions as I see them. Is the art in the background or is it in the forefront? Is the art obscured or blocked by anything? Is the art part of the plot or is it interacted with, or is it merely set dressing? How long is the art on screen for consecutively at a time? And how long is it on screen in the aggregate? Is the entirety of the art on screen, or is it only a part of the artwork? Finally, the most important consideration is what would an average lay observer be able to determine about the art featured? Is it identifiable? Is it noticeable? Is it eye-catching? So the big question is, for how long is Shawn Coss's artwork visible on screen? So I gotta be honest with you, I don't think this looks very good for Netflix. Here are some of the issues I noticed just by looking at the scene. The artwork is clearly visible, so this isn't a what women want situation, as there's no blocking of the art. This isn't a 7 situation, as the art isn't so small as to be difficult to make out, and it's even worse than the rock situation, as you can see the artwork clearly in its entirety. What's worse is that this artwork isn't really background set dressing. A character in the show is interacting with the artwork by pinning a piece of it to the wall. The art is actually part of the plot. Now, I don't know how big a part of the plot it is, but it's a part of the plot. The only factor that is mildly in Netflix's favor out of all the factors we discussed is the fact that the artwork is visible for only an aggregate of 15 seconds, which is less than the aggregate of 30 seconds or so in all the preceding cases that we mentioned. However, in those cases, no shot ever showed the art consecutively for longer than 5 seconds or so. In this case, the art is on screen consecutively for 15 seconds. Without interruption or blocking or zooming out from the art, it's 15 seconds straight, start to finish. Remember, the central inquiry is what would the average lay observer be able to discern about the artwork? Is the artwork on screen for long enough and in a prominent enough fashion so that an average observer could recognize it and identify its stylistic elements? I think, without a doubt, the answer is yes. You can not only discern the stylistic elements, you can tell pretty much exactly what artwork it is and all the details of the artwork just by looking at this scene. So I'm curious to see what Shawn Coss, the artist, decides to do. I don't know if he actually has a case or if Netflix actually didn't have permission to use this artwork. You know, just because the artist didn't give you permission doesn't mean that they don't have a valid license from someone else. But the ball is in the artist's court, and if he has a claim, we'll see if he decides to take any shots at Netflix. But until next time, this is Reels and Gavels.